SCOTUS speaks with its mouth wide shut on the BNL Productions case. This is the case on gun show bans in California. Let's talk about it. Hey everybody, welcome back to the channel today. We are back at the Supreme Court of the United States. The action, the inaction, let's just go ahead and talk about all of it in the past couple of weeks. To do that, we have brought on CRPA's president. That is Chuck Michel. Chuck, thanks for being on with us today.
Always a pleasure, guys. Thanks for having me.
Yeah, absolutely. And guys, before we get into this today, please, as always, be sure to like, share, and subscribe to these videos. It really helps get the message out as far and wide as possible. We're doing a lot of work in this state to move the 2A ball forward in the right direction. And the more eyes that we can get on these videos, the better for the cause. So please go ahead and like, share, and subscribe. It really helps out. So Chuck, before we get into it today, I did find this article from Bearing Arms. I wanted to go through it really quick. Of course, this is in reference to the BNL Productions case that we filed to go to the Supreme Court last week. The article is titled, "SCOTUS Silent on Snope Turns Away Challenge to California Crackdown on Gun Shows." Jacob, if you could pull this up for everybody. It reads like this. The Supreme Court continued its pattern on Second Amendment cases in its order list on Monday. That, of course, is last Monday. Silence on cases dealing with assault weapon and large capacity magazine bans that have been listed for its weekly conference since last December, and turning away more recent cert petitions dealing with Second Amendment issues beyond those at the heart of Snope and Ocean State tactical litigation. BNL Productions, that is our gun show case, isn't or wasn't just a Second Amendment case. Instead, the court was asked to resolve a couple of questions around the First Amendment rights of gun buyers and sellers, in addition to a question related to the right to keep and bear arms. As a result of the Supreme Court's inaction, the screwy laws in California allows guns to be offered for sale on state-owned property while prohibiting an offer from being accepted will remain intact for the foreseeable future. There is one other legal vehicle that could provide gun sellers and gun show promoters some relief, however, as plaintiffs, that's us, noted in their cert petition. It goes like this. Alternatively, the court already has on its merits docket a case that takes up legal implications of commercial speech rights associated with exercising Second Amendment rights. That is Smith Wesson Brands v. Estados Unidos Mexicanos. The underlying controversy in that case can be restated as whether a manufacturer can be held liable in tort for merely marketing its lawful products. To the extent this court chooses to flesh out the Second Amendment ancillary commerce rights necessary to exercise the right to keep and bear arms, this court can hold this petition and then issue appropriate instructions in the case upon disposition of the Smith Wesson case. Back to the article. Unfortunately, SCOTUS chose not to hold on to BNL Productions, but depending on what the court has to say in Smith Wesson, there may very well be grounds for a new challenge to the speech codes enacted by the California legislature. So I guess the meta news here is that the Supreme Court did deny cert for the BNL Productions case. That means that while the Supreme Court isn't going to look on it, we do need to continue working there. Although, Chuck, if I can bring you in here, there is one question that I wanted to kind of address right off the bat. You know, with the Supreme Court holding Ocean State Tactical and Snope for so long, I don't know about you, it's kind of lulled me into the feeling like they're just going to hold on to everything. Were you expecting SCOTUS to address BNL in its first conference, whether it goes this way or a different way? Did you expect them to address it in the first conference?
Well, I mean, statistically speaking, they do address most cases in their first conference. They make a decision based on their first conference, then they issue on Thursday, and then they issue order on Monday. Snopes and Ocean State Tactical, like some other very high-profile cases, like the abortion case, those are unique in the number of times that they postpone that conference and keep trailing the case. I think in Snopes and Ocean State Tactical, it's been postponed 14 times. The Dobbs case, abortion case, I think was postponed, I want to say 15 times. So it doesn't necessarily mean that they're not going to take it, although If they do it 4 or 5 times, it typically means that one of the justices or more than one is writing a dissent about why they should take the case, but they're not actually going to. So yeah, it wasn't particularly surprising that they ruled on BNL initially. I think they saw BNL, and because it was a hybrid case, it was First and Second Amendment issues, and the commercial speech. In the First Amendment legal world, your political speech gets more protection than commercial speech, like an advertisement. And there's a big line of controversy and discussion about whether or not that kind of a distinction is appropriate. Why wouldn't all speech get equal protection, so to speak, from censorship? If it's commercial or political, it's still speech. And so that was the point with BNL. They were applying this lower standard of protection to the speech because it was commercial, even though it was intertwined with Second Amendment, because you're selling a firearm. The sale is still commercial. And they drew this very strange distinction. The Ninth Circuit drew a very strange distinction between offering for sale and accepting an offer for sale on state-owned property. And remember, this only applies to state-owned property. Gun shows can still be held on private property, and they can still be held on state property. You can still have guns. You can still have things offered for sale. You just can't accept an offer to buy. So we're working on workarounds for that. We have to go back down to the trial court and find out exactly how that court interprets the Supreme Court's opinion and what it does and does not allow to take place at gun shows. Meanwhile, there's extended contracts in Central Valley gun shows, so those shows will go on for a while. And the Smith and Wesson case may get rid of that distinction between commercial speech and political speech, or change it, in which case there could be another challenge to the gun show ban based on the new law, because the Ninth Circuit will have interpreted the distinction between commercial speech and political speech wrongly, based on what the Supreme Court says in the Smith and Wesson case.
So yeah, let's talk about that pathing really quick. So I mean, we do have a judgment for BNL. That's what ended up forcing the hand to the SCOTUS brief. But having denied it from SCOTUS, is there any other path for the litigation to go? I know. Well,
remember, there's two different cases. One had a judgment, the other one didn't. So we're back in court on one of those. And actually back in court on both to see exactly what the judgment should be, how it should be worded, and what is and what isn't allowed.
Okay, well, yeah. Having said that, then, when you're talking about another challenge that can be brought, would it be the other challenge that currently sits in the court system, or are you thinking an entirely new challenge altogether?
It kind of depends if that case is still there when the Smith and Wesson decision comes down. But it may very well be a whole new challenge. So we really do need support. Look, they want to eradicate the gun culture. They want to murder the gun culture. That means gun shows. That means FFLs. That means gun ranges. That means hunting. That they want to red tape all of those rights to death, all of those activities to death, because they know that if they can stop people from learning about guns and going to the range and having a good time or going hunting, that eventually the gun owning population will go down. It'll just be the folks who have a gun in their house for self-defense. And then they also want to obviously try and restrict guns, CCWs, and where CCWs are valid and how hard it is to get one. All of this is part of the war against the gun culture. And we have to fight at every turn. And so if people can't get together, people go to gun shows because they get deals on ammunition and guns. But there's also all these other ancillary activities going on at training and gun law education programs. And, 70% of the tables don't have guns or ammo on them. They're a lot of big beef jerky, as it turns out, which is really good. I buy it every time I go to a gun show. But so we want to keep those shows alive because we want to protect the ability for the gun culture to thrive in all of its various forums. So we need support for that and for all the other lawsuits that we're involved with to preserve the Second Amendment right in all of its forms.
Right. So, I mean, whether you're going up or down, there is still a path forward here for this line of argumentation, or at least that's what you're making it sound like. And call me the layman here, but you got a First Amendment challenge, you got a Second Amendment challenge. It really seems like something that would be ripe for the Supreme Court to comment on.
We were very surprised, frankly. I mean, obviously, statistically speaking, the Supreme Court rejects 90+% of the cases that ask it to hear their appeal. But we were really surprised because the BNL case presented a lot of issues that are sort of front and center for the Supreme Court, commercial speech and Second Amendment wise. So, but we'll see what they say in the cases that come up next. I mean, either the Snopes case or the Ocean State tactical cases it's all about the methodology. And they applied the wrong methodology on the Second Amendment analysis in the BNL case too. So that door could be reopened when they straighten that out. So the game is not over for this or any of the other cases. We just got a bad ruling out of the Ninth Circuit on the Duarte nonviolent felon ability to get their rights restored case. And Judge Van Dyke, thankfully, is one of our biggest champions up there, calling out the other justices on the Ninth Circuit for all the things that they're getting wrong. And so it could very well be that the Supreme Court's waiting for probably for our Duncan case to go up there, and then they may do Snopes and Duncan at the same time.
Well, let's talk about that for a second, whether you want to call it a surprise or your Monday sigh of disbelief as we continue to see these order lists come down. We continue to see Ocean State and Snope get relisted and relisted. What are your thoughts on these? I mean, if you look at the data, which I did look at some of the data a while ago, it looked like the opportunity to get a case taken by the Supreme Court was best in the first 3 or 4 relists. After that, after the 5th one, it goes down dramatically. And then it seems like the rhetoric online now that we're up to 14 relists or whatever it is, every time it gets relisted, the chances that it's going to get taken by the Supreme Court goes up and up. And then over here, kind of coming out of left field, you've also got the Duncan case that I feel is another one of those that's really ripe for the Supreme Court to take. So what are your feelings, and how are you viewing this field of these cases at the Supreme Court, the ones that continue to be relisted with Duncan coming in?
Well, it probably does increase the chances that they'll take it, but it's a lot of this is tea leaves, But one thing is absolutely clear. The Supreme Court has to take another Second Amendment case because the Ninth Circuit and other circuits, anti-gun owner circuits, are just twisting the Bruen analysis to suit their own predispositions, their own bias against gun owners and gun ownership, and in favor of government being able to ban just about everything. So the Supreme Court's got to set the record straight, and they know that. And Alito and Thomas especially know that. And I'm sure that hopefully sooner, but maybe later, they will take another Second Amendment case and straighten things out.
Well, something certainly that we're going to look forward to. We'll continue to report on it, Chuck. I look forward to having you back when they do finally take up that case and we can talk about all of the potential there. I know you're a busy guy. I want to thank you for coming on and sharing with us today.
Folks, just keep in mind, this is a historic time for the Second Amendment. A lot of things are still being settled out. CRPA is one of the leaders in the fight. We're working with all the other groups, pro-Second Amendment groups, to advance our cause, and we need your help. We really need donations. We give generous rates to the nonprofit CRPA, and all my time's pro bono. So if you can help us out a little bit with a donation and a membership, we'll put it to good use.
Absolutely. I couldn't agree more. And again, I just want to thank you for coming on and sharing with us today.
Pleasure, guys. Thanks for having me.
Absolutely. And guys, if you like videos like these, if you like following along with the Second Amendment litigation, and if you want to contribute directly to that fight in Second Amendment litigation, please be sure to like, share, and subscribe to these videos. It really helps get the message as far and wide as possible. We need to collectively come together and push this Second Amendment rights ball forward in the right direction. Thanks again, guys. We'll see you on the next one.